Yep.
Everybody recording?
Yeah.
Okay. Gabby, you're gonna do the intro on three. Ready? 3, 2, 1. We're back. Stars on the mic with our podcast. Elton Aguilera here with Stars. Today we have.
Carlos Aguila, happy to be here, Elton. Thank you for having me.
Oh, thank you for being here. So to be started here, we have our first law firm on our podcast. Like, tell me, how did you get into this? Like, what was your beginning? How did you start all this?
Well, it's always been a vision of mine since I was young to one day open up a law firm. Believe it or not, I've been in wanting to be an attorney since 18 years old. I first started working at a law firm
18.
at 18 when
Wow.
I was a senior in high school. And so I always wanted to do this. And, thankfully I was able to open up my practice 3 years ago. And it's been great. It's been very, very rewarding.
Oh, that's amazing. The question I have to get straight up to, why guardianship law? Why not criminal law? Why not tax law? Why guardianship? What made you go down the journey of guardianship?
So guardianship is something that's personal for me. I'm an autism uncle. My niece and goddaughter is an individual with autism.
Okay.
And so I saw firsthand sort of the lack of information and education that's out there regarding guardianship. My little sister is actually a behavior analyst.
Oh, very cool.
And so she would oftentimes reach out to me and say, Carlos, there's so many families that need assistance in this area, and so I wanted to be able to assist families in such an important portion of the transition into adulthood and make sure that they have that information and that education so that they can make an informed decision about what their options are.
Yeah, not many people know about guardianship. Once a child reaches 18, like everything changes, and they have no idea like the importance of having a guardianship. Walk us through the process. Like, how early should they begin the process for a guardianship?
So you want to start thinking about guardianship when your loved one is approaching the age of 18. So what we generally recommend is, starting around 3 months prior to the 18th birthday, you should already have a plan in place as to whether or not, you're going to actually go through with a guardianship if it's necessary. Every
Okay.
individual, has their own unique abilities and it may or may not be necessary. But if it is necessary, then yeah, I would say by 3 months before the 18th birthday, you should already have an idea of what your plan of action is going to be.
Okay. And how long does the process take? Like from the time they meet you till it's actually done? Like, walk us through that. Like, how does it go?
So the time frame is going to depend a lot on the court's availability.
Okay.
So, but starting from the very beginning, right? So when a client engages our office, there's usually about a month of time where we're just working together, collecting information, gathering documents that we need. So things like IEPs, medical reports, things that we need to gather to be able to present to the court. And that usually takes about a month, sometimes 2 months. And when we actually file the paperwork with the court, depending on the court's availability, it's usually a month after we file, we get the hearing date.
Okay.
Sometimes 2 months out, really just depends on the county. So process from start to finish, depending on the type of guardianship, could be anywhere from 4 months to as long as maybe 7 months from
Oh,
start
wow.
to finish.
Okay. And you just mentioned something, types of guardianships. Like, could you explain that? What do you mean types of guardianship? Because there are different, when you work with children of, inclusion and special needs, there's different types. Some are completely sociable and everything, but academically they could be very low. The decision making could be not there. Like, what do you mean by different types of guardianships? Could you explain that?
Sure. So there's a variety of guardianships in Florida.
Okay.
And so whenever I'm working with a potential client, I first want to get to know the individual themselves, right? I want to know, if guardianship is even necessary, right? Because guardianship is something that it's a big deal. We're
Yeah,
talking
it's very
about,
big.
yeah, we're removing rights from someone, right? And giving rights to, generally it's mom, dad, or a caregiver. So depending on the circumstances, we look at least restrictive alternatives, right? So if the individual needs assistance, but they are capable of signing documents like a durable power of attorney or a healthcare surrogate,
Yes.
that's something that we can explore to see if it's an appropriate fit. But if not, then we're looking at the different types of guardianships.
Okay.
So in Florida, generally we have guardianship advocacy, we have limited guardianships, and then we have plenary guardianships, which are the traditional type of guardianship that you think of when you hear of guardianship.
Okay. So that would be the parents would be able to make decisions and stuff, or caregivers for the child once they move past the age of 18 for what health reasons, financial reasons, or employment, or
Yeah, I mean, what you've mentioned is exactly right. So decisions regarding medical decisions,
Okay.
financial decisions, re-enrolling in school, right? The decision to maybe engage an IEP advocate, decisions regarding where they're gonna live, um, to work, all of these different things that come up when the individual turns 18, they receive all of their rights,
They're an
and
adult.
they're an adult,
Yes.
so that's not a bad thing, right?
No, it's not.
That's a good thing. We want to make sure that we're protecting their rights. But if they need mom and dad or caregiver to continue to advocate for them, then we explore guardianship to see which are the rights that should be removed and given to the guardian so that they can continue to advocate for them after 18.
So you mentioned something that me being a school teacher, I'm always looking for the least restricted environment. Would a guardianship be among the same thing? You want to have the least restricted, you want to give as much independence to the person as necessary, or how would that work?
So we always want to begin with the framework of preservation of rights and
Okay.
preservation of human dignity. So
Oh, yes.
keeping that perspective in mind, we want to think about, what are the strengths and what are the potential areas of limitations, right? And depending on that, we can guide the family on which it would be the appropriate type of guardianship. So yes, we want to begin with a least restrictive alternative to full guardianship,
Okay.
and from there we can sort of expand to see if we need to go into something more extensive.
Oh, very cool. Okay, so this is all great. So let's talk money. So a family contacts you for guardianship. What should they expect? Cost, fees. Like you mentioned, different type of guardianships. What should they expect?
Yeah, so guardianship, the fee associated with guardianship is going to depend on the type of guardianship and, of course, the complexity of the case. If we're talking about a guardianship advocacy proceeding, that's really the most cost effective and quickest way to obtain guardianship. And, in terms of a range, a parent can expect to pay anywhere from 3,500 to 4,500, just depending on the complexity of the case and also the amount of applicants. If
Okay.
it's just one applicant versus two applicants, that's where the fees tend to change.
Some families have multiple siblings.
Well, what we do for families is if they want to have two guardians, so a guardian and a co-guardian, we can actually file for two. So we'll have
Okay.
a main, we'll have a guardian and a co-guardian, and then a lot of families are concerned about, well, what if we're no longer around? Who would step in if
Mm.
neither of us can do it? And so we prepare what's called a standby guardian, and that's the third in line that would step up if there's a need.
Oh, wow. So based on the complex, like how complicated it is, the complexity of it is the fees will vary based on that.
Yeah.
And then I'm assuming you would walk the family through the entire process from start to finish.
Yeah. We walk the family through the entire process. And so, we assist them with everything. So we'll gather all the information from them. We'll collect all the documents that we need from them. And then we'll prepare all of the court filings. We'll file with the court. We'll appear on behalf of them at the court hearing. And then we'll comply with all of the other additional requirements to finalize the guardianship. And there's requirements like fingerprinting. There's a guardianship course that they need to take. We connect them with the different resources on how they can go ahead and do that so that we're in compliance with the court.
Oh, very cool. So let me ask you a question. So let's say a family completes a guardianship when the child's, 13, 14, 15. By the time the child reaches 18, there's been a change in development or the child wants to do something else or just a change in the family and they want to make edits or changes to the guardianship. Is that possible?
Yeah, you can definitely modify the guardianship or the rights. So if an individual maybe lost a right at 18,
Hmm.
but now they have the capacity to exercise that right, then we can request that the court restore the right, and the attorney can do it, or the individual themselves. They can actually petition the court on their own and ask the court to restore a right.
Okay, yeah, because from our end, working, inclusive children, special needs, the goal is always independence. You want them to have as much independence as possible. So I'm going to assume, based on what you're telling me, it would be kind of the same thing. You want them to have as much independence as possible. They do require supervision still, but you kind of want them to be their own person. Just go.
Absolutely. I mean that's the goal, right? Obviously every individual is different, and everyone has their own unique abilities. But of course, if at 18, they're not ready at that point, but they're working towards that transition and they can get there, then yeah, if they're able to exercise these rights later on, then we can certainly ask the court to restore the right.
So aside from guardianship, what other services can families, benefit from you?
So one of the things that we do as well as guardianship is special needs planning. And what special needs planning is, it's developing an estate plan that incorporates a special needs trust.
Oh, very cool.
Yeah, and so the idea behind special needs planning is to plan for your loved one's future when mom and dad or caregiver are no longer around, to assist them,
Hmm.
and we're talking about providing for them financially. And so the way that we do that is we develop an estate plan where the individual will be able to receive an inheritance, and it can actually be funded through a special needs trust. And the reason why we do it that way is because if the individual is receiving public benefits, and they're public benefits that are means tested, meaning it's based on a financial need,
Hmm.
they don't become disqualified when they receive an inheritance from a loved one, or sometimes there could be if there's a lawsuit involved and they're receiving a settlement money. That's another situation where a special needs trust may need to come into play so that we can protect them in terms of being able to remain eligible for public benefits.
Oh, well, I get that all the time. People I know, they can't work past a certain number of hours. The reason being they don't want to lose their benefits and all that, STS or whatever. They're like, no, no, I can't lose my benefits. Oh, that's very cool. That's good to know.
Yeah, so this is a solution to that. It's something that's important, and I know it's a concern for a lot of families. That while they're alive, that they're able to provide.
Hmm.
But what about when they're no longer here? And I know that's something that keeps parents up at night, and so the solution to that is developing a special needs plan, so that you can care for your loved one. When you're no longer physically here, able to do it.
Oh, very cool. That's important to know. This is all incredible information. So if you could give the families one message, what would it be?
It would be that to take this serious. If your loved one is an individual that by the time they turn 18, they still need assistance, they still need you to advocate for them, then you really should be exploring guardianship. You never want to be in a situation where you're maybe in a hospital setting, or maybe you're dealing with law enforcement, and the people that you're confronted with are telling you, mom, dad, caregiver, stand to the side. This person's over 18. You can't help
Mm,
them. It's very important. And not only that, but even applying for public benefits, being able to assist them in filling out the application and applying on their behalf. These are all things that are very important. So if your loved one needs assistance, continued assistance after the age of 18, consider guardianship, consider the alternatives, and it's something that you really need to do.
yeah, parents, nobody knows their kids like them. So yes, take this very seriously.
Exactly.
So based on what you just said, let's say we have somebody over 18, ASD, nonverbal. They're having a meltdown, it happens. Police get involved. Will the police go to the nonverbal ASD or the parents, or like how does that work?
So it's gonna really depend on the officer. Technically, they need to deal with the individual because the individual's over 18. So they have no obligation to get mom and dad involved.
Really? Like
And
I never thought of that. Like,
yeah,
wow.
and it's difficult. You mentioned an individual that maybe has you know limited output, limited verbal output, right?
Hmm.
Or what about the individual that is verbal but clams up in a situation where they're confronted with individuals that they don't know, or they feel anxious. They're not able to speak up on for themselves, and so what would happen there. And a lot of times, police officers may not understand that they're dealing with an individual with an intellectual or developmental disability. So with guardianship in place, you know, no one can tell you as mom and dad or caregiver that you can't be involved in this process. From dealing with the officer, if we have to deal with the state attorney's office, you can assist them in that regard. And if we go as far as it's something that gets before the judge, we can show the judge that this is an individual that is under a guardianship, and that's going to assist in that process. The judge will be able to see that and recognize that. So yeah, that is something that we're familiar that with families that they have that concern, that maybe their loved one, has a history of something, and there's a potential that something like that could happen when they're
Hmm.
over 18, and so it's a concern.
Oh wow. So the officer, it would come down to the officer, but legally the officer would just tell mom and dad step to the side. I'm gonna speak directly to a nonverbal person.
Right.
Wow, I had no idea. That's incredible. So yeah, guardianship very important, and I would assume it's one of those things. The sooner the better.
The sooner the better. Again, depending on the circumstance, not every individual needs a guardianship,
Hmm.
but if it is an individual that does need it, then yeah, I mean, you don't want to be with a gap in time from their 18th birthday to beyond without anyone there to legally advocate for them.
Oh well. Is it possible for someone who's like, as they get older, to kind of like outgrow a guardianship? Like they still under guardianship, but they kind of don't need mom and dad to make decisions for them. Like, is that possible? Or
Of course, it's possible. I mean, that's why Florida recognizes that possibility. We have a whole process for restoration of rights.
hmm
So if that happens, then absolutely. That's a fear that we have a lot of times for parents. They're concerned that, oh, if we do this, that's it, it's permanent, and it can never be modified, it can never be undone, and that's not true. We are, in Florida, we're huge on preservation of rights. We're
okay,
huge on, making sure that individuals under a guardianship are only there if it's absolutely necessary. And so there's a lot of safeguards involved. We hear stories from other
all
states
the time.
in the news, right, of this guardianship that should have never taken place.
People taking advantage,
Mm-hmm.
and yes, you hear it all the time. So the I don't want to say child because they're not a child anymore, but they could pretty much advocate for themselves to edit or modify the guardianship if needed.
It's in the statute. Yeah, they can petition the court on their own to have their rights restored.
This is great information, man. I'm so glad we did this. Parents, please follow him at Aguila Law. I'll have the Instagram handle, up on the screen. I also have all his contact information on our description and everything. What would you say would be the best way for parents to contact you? Call, email, or
Yeah, they can call our office. It's 305-967-8554. Or if you have a question you want to email us, you can email us at info@aguilapa.com.
thank you so much for being here. We look forward to working with you again in the future.
Thank you for having me.
Perfect, dude.